So please allow me to introduce the lecturer of our morning sessions today. We have with us Ms. Catherine AMIRFAR. Ms. AMIRFAR is the partner and co-chair of International Dispute Resolution Group and the Public International Law Group at Debevoise and Plimpton LLP. Ms. AMIRFAR has over 20 years of experience representing states and international organizations before international courts and tribunals, including the Investor State Tribunals and International Court of Justice. The topic of her lecture today is Investor State Dispute Settlement. Thank you.
Thank you very much. Can you hear me? Yes, good morning. Lovely to be here. Lovely to see you all. It's been, I think, it's hard to believe that this is only the third year of this seminar because it has just been so superbly kind of organized and in terms of the content and the presenters. So I really do consider it a great privilege to be here today, and I'm grateful for the kind invitation to speak about ISDS. So in the time that we have together this morning, what I'll do is draw from my experiences as lead counsel, as arbitrator, to really try to give you a perspective on ISDS. That is what I'll call inside baseball, which would be appropriate for US and those Japanese lovers of baseball here, but really try to give you the internal perspective of the ISDS system and bring to bear some of the respondent side considerations. So that's my goal today. I welcome questions throughout. I think we all have a better time when it's interactive, so at any point, please do raise your hand and let me know that you'd like to join, and I'm very happy to call on you. So I want to start with some basics, but before I do so investor-state dispute settlement, who has had an issue arising in the ISDS system in their portfolio before? Who's had the experience before? This could be international arbitration or investor-state treaties, anything of that nature. Excellent. So we're going to start together on kind of some table setting. So what I will do in the two parts is start with table setting on the introduction, give you a sense of the ISDS system, how it's developed as a matter of international law, and then get into the top 5 strategic considerations for states in investor-state arbitration. At that point, I think we'll be ready for the break, and then when we come back together, we'll take those observations and that learning and apply it in a specific context of a case, a real case that I was involved in, the Hydro versus Albania case, to give you a sense of how some of those dynamics, some of those practices actually played out in a real case. And then we'll talk a bit about the future of ISDS, because you'll be interested to know that we are really at a crossroads in terms of the international conversation about inter-investment state dispute systems. So that is, and it says questions at the end, but please do ask me questions throughout. So to start, what is arbitration? Arbitration is a procedure, and to put it simply, that is a creature of consent. And you'll hear me say that and again, because this aspect of the international legal architecture is very much based on consent. So arbitration is an agreement of the parties, and we'll talk about what that agreement actually looks like, to submit a dispute to one or more arbitrators. It's usually binding. There are some instances where parties have agreed to non-binding arbitration. We'll talk about that a bit. But it's usually binding as a way to resolve an international dispute. In choosing arbitration, what the parties basically have done is opt out of court. And that can be an international court, it can be a domestic court, but international arbitration is a consent-based system by which parties have agreed to create a transnational system of justice that, again, is based on consent. It won't surprise you to know that there's different kinds of international arbitration. We're going to focus on one in particular, but it's useful to get a sense of how the consent manifests internationally. It depends on the subject matter of the dispute, the underlying legal instrument, the governing law, the nature of the parties to the dispute. This is not intended to be comprehensive, but it gives you a general and very broad categorization. So of course the arbitration agreement you see is in the center, because that's where the parties' consent to resolve the disputes emanates. And as you'll see, that's the basis on which the arbitration proceeds. So you always come back to the concept of consent. There's international commercial arbitration. You see that on the top left. That's where the instrument of consent is a typical commercial contract, usually between two commercial entities. Sometimes states are involved where there's concession contracts, sometimes not. But in those contracts, there'll be an arbitration clause that says any dispute, usually, arising under this agreement is subject to arbitration. And as I think many of you know, there's different arbitral institutions across the world that administer these types of commercial disputes. So that's the international commercial arbitration sphere. Then there's specialized international arbitration. And you may, of course, have heard of the World Intellectual Property Organization, WTO, the Court of Arbitration for Sport. There's different types of specialized tribunals, and those are two examples of arbitration specialized tribunals. On the bottom right, you have interstate arbitration, which is becoming actually more and more, I think, frequent. But over the last 200 or so years, there have been very high-profile examples of arbitrations between two countries, where the countries agree to submit a particular dispute to arbitration. The Alabama cases are a very big example between the US and England as to how arbitration can play into a dispute between two countries. And then the majority of the time that we have together today, we're going to be spending on the lower left-hand corner, which is investment arbitration. And that's a system by which investments and protections for investments are subject to arbitration on the basis of usually treaties, usually bilateral investment treaties, or in some instances multilateral treaties that serve as the basis of consent. So that's what we're going to focus on for purposes of today's conversation. So the origins of investment protection. There's a really very clear demarcation in the international legal architecture as to how these kinds of investor-related disputes were handled. But I'd say before the 19th century, if you use that as a very rough demarcation, foreign investors, in and of themselves as investors, whether it's individuals or companies, had no rights or legal capacity on the international plane, which of course makes sense, given that international law is largely a construct between states, agreements between states. So there was no real rights or capacity before the 19th century. Then industrialization, foreign development, assistance caused an increase in foreign investment that led to the development of different types of protection systems that were intended to protect investors' rights to travel and trade. And so you had these favored nations, these bilateral agreements, agreements that governed citizenship, agreements that governed different types of rights, including investment rights. But in those agreements, in the very old generation, there wasn't a dispute resolution clause. So if an investor felt aggrieved, so an investor of state A invested in state B takes an adverse action against the investor, there was really no option except for the investor of state A to go to their government. And depending on whether the government chose to expend political leverage or resources, that's where their remedy lay. You either, the government, your host government, your sponsoring government of nationality usually, either takes up your cause or doesn't. And there's lots of instances in the 1830s going into the First World War where there were actual, it's called in the sense of gunboat diplomacy, instances where governments would send warships out, and Teddy Roosevelt was famous in the United States for doing this a lot, would send warships out into the world in protection of US investors abroad. And there's other instances of other countries doing the same. But it was very much the idea that might makes right. It wasn't a justice system per se. It was the idea that if you had the political capital, the political connections, the political leverage, and you could get your country of nationality to take up your cause, this was what you'd revert to, which is the era of gunboat diplomacy. Now that started changing in the mid-1950s. And that 1959 was the first bilateral investment treaty between Germany and Pakistan. That one had a state-to-state dispute resolution mechanism. So there it wasn't, again, giving standing, if you will, or some legal rights or personality to individual investors or corporations. It was state-to-state. But it was the beginning of something in the sense of if there's a dispute, there should be some type of ad hoc mechanism, here arbitration, to resolve that dispute. And that was the international conversation that took hold. And by 1965, you had the establishment of the International Center for Settlement of Investment Disputes, ICSID. Who's heard of ICSID before? I see a few. So ICSID was a bit of a game changer, because what ICSID did is create really an international conversation about what internationalized systems of justice could look like. And in this internationalized system of justice, it actually did something that's really extraordinary when it comes to international law, which is obviously a construct between states. It actually reached in and conferred standing rights, obligations on individuals and corporations who were investors. And in that moment, you created a transnational system of justice that was really unprecedented. So this was a sea change in how international law approached disputes. And that is a fundamental and kind of transformative aspect of what these series of treaties, and I'll get into some of the details of them, did. But really, I can't emphasize enough how different this was in terms of the international law that followed versus the international system that was before. But it was a game changer in many ways. And then of course, you see proliferation of the concept. And another moment, a pivotal moment, was in 1981, where under the Algiers Accords, the US and Iran, after the hostage crisis of '79, decided to do something pretty monumental. They established an international tribunal specifically to deal with their bilateral disputes. And in doing so, both states actually extinguished what were hundreds of domestic litigations in each of those countries. So you can imagine a US investor aggrieved about Iran was suing Iran in US courts. An Iranian investor aggrieved about the US was suing the US in domestic courts, with no hope really of resolving those disputes in domestic courts. So what the countries did is they agreed to take those individual claims, extinguish them, and that was pretty remarkable, because what the countries did is they exerted their personality as states to extinguish domestic claims and said, instead, if you want recourse, there's an international mechanism, and that was the tribunal. And the US-Iran Claims Tribunal actually, in terms of procedure, substance, really was a fundamental moment of modeling of what international tribunals could look like. And so this was in 1981. And then again, what you see is proliferation of a transnational system of justice, mostly in the form of these investment agreements. And these investment treaties, and we'll go through a few of them, what they do is two very important things. They codify standards of protection. What does it actually mean to protect an investment? Those are substantive standards. And they provided clear dispute resolution mechanism. So you had the substance, but you also had the procedure. You had a forum. You had the ability as a claimant to try to vindicate rights against respondent states. So that's really where the system, I would say, took off, is in the 1990s. So here's just a graphic, and what this does is illustrate kind of with the before and after, if you will, of what modern investor-state arbitration does. So it doesn't require the intervention of the home state in the prosecution of the claim. It does not require a prior contractual relationship between the host state and the investor. It was called by a lot of, I'd say, individuals who are not fans of the system as a contract without privity, which, as you know, can really violate the sensibilities as lawyers, is the idea that you could actually be dragged into court without having specifically agreed to be dragged into court or before a tribunal in that instance. But what it does do is it allows the investor, who again could only go through state A, the home state, to either go through the treaty that has been that has been agreed between state A, the home state, and state B, or to go through its concession contract, which sometimes might have a dispute resolution clause. Now, you can imagine if you're an investor, the dispute resolution clause in your concession contract is probably not an international dispute resolution clause. So the investor faced a choice between going to the domestic courts of the host state, where the investor might think that's not necessarily the place to be where I'll have a chance at justice, or to go under the treaty. So as you can imagine, lots of investors chose to go under the treaty. The idea is that that would be a neutral forum for the adjudication of international disputes. And hence, when I referred to a transnational system of justice, this is what these treaties were intended to establish. So I want to go back before we move on to something that is really key, and it's part of the advice I give respondent states all of the time, because usually, obviously, states are respondents in these investor state claims. The respondent states are here in that forum, in that international arbitration procedure, by virtue of consent. So where is that consent manifest? It's manifest usually in the terms of the treaty itself. And that is very important because the terms of the treaty will in many instances place limits on that consent. So it's not as if the respondent state has agreed to all disputes all the time, no matter the circumstance. The treaty itself serves as the basis for understanding what are the contours of that consent. And in my practice advising states, many hours are spent going through jurisdiction, admissibility, all based on what are the restrictions of consent, how are they manifest in the treaty, and does the claimant have the ability to actually bring this claim under the treaty? So I cannot emphasize enough how important consent is from a respondent state perspective or otherwise in thinking how and why and in what circumstances the international arbitration can proceed. So here on the slide you have just an example of the 2012 US model BIT, and there you can see that the US has chosen, at least in the model BIT, to place some very discrete restrictions on the nature of consent. And that includes, for example, time restrictions, that certain passage of time from when the claim was deemed to have arisen is important, or written waivers, or that there needs to be a written request for arbitration. Whatever it is, there's lots of examples of bilateral investment treaties that are quite specific as to the nature of that consent. And as I'll show in a moment, here you kind of get a sense of how these treaties proliferated. Currently, by the end of the end of 2024, there's 2,608 bilateral investment treaties out in the world. And most of them were agreed in the 90s. So you can see that this transnational system of justice became really popular in the 90s, in the sense that we're going to have these bilateral investment agreements with the goal of promoting foreign investment that would benefit the host state, but we're also going to agree usually to the arbitration provisions. Not across the board. If you look at some of the older, what are called old generation BITs, and Russia, for example, entered into hundreds of these old generation BITs that only have, for example, arbitration of compensation claims. So not the whole claim, just a piece of it. And there's been a lot of litigation about what those provisions actually mean. But the ones that are in the 90s tend to have these full-blown investor state dispute resolution clauses that include a full-blown arbitration clause. And that has really, I think, lent itself to a very comprehensive system of bilateral investment disputes. And so you see hundreds of these cases going through these bilateral investment treaties themselves. So the other thing I'll point out is after decades of growth, as you see, in recent years, that's been shrinking. In 2023, countries and regional organizations concluded around 29 of these international investment agreements, and at least 15 of those entered into force, and 4 were terminated in 2023. And as we'll talk about in a moment, the state conversations around bilateral investment treaties are constantly in flux. And I would say right now, we're probably at a point where there's far less state support for these bilateral investment treaties and the arbitration procedures that they contain. But I'll come back to that at the end. But suffice it to say, there are thousands of these treaties out there, and most of them have these robust arbitration provisions, which is why you see the proliferation of these international arbitration disputes on the international plane. So what do they cover? I mentioned before that they are about substantive treaty protections, but what does that actually mean? So in general, investment treaties cover investments by an investor of one country in the territory of the other country. Each of those words is subject to lots of disputes about definitions, what constitutes an investment, what constitutes the territory, especially in context of armed conflict. So there's lots of jurisprudence that has arisen around these seemingly, I'm sure, when the negotiations occurred, simplistic terms. But investments, I'd say over the years, for the most part, the definitionally have gotten broader and broader and broader. And in today's world, for example, you can imagine for these huge social media tech companies, part of the conversation is social media consumer bases. Is that an investment under a bilateral investment treaty? So as you can imagine, as technology and businesses change, these terms are given new and different content. But for the most part, the concept, the restricting concept is there an investment in the territory of another country? So the most definitions, I would say, in BITs, with the exception of some of the older generation BITs, have very, very broad definitions of investment. Any asset, any kind of asset. And I would say a lot of instruments, monetary and otherwise, fall under any kind of asset. The individuals that are typically protected are investors of a contracting state, defined to include individuals who are nationals of the state, or companies organized under the laws of the state. Now that, in and of itself, seems like, again, simplistic, but questions have arisen. Do dual nationals count? In some cases, that's actually disqualifying. Does it matter if there's a country of nationality in a first instance for a corporation that is recognized in that country or incorporated in that country, but has operations entirely outside of that country? Is that an investor of the state of nationality? So all of these myriad questions arise about status because, of course, you have to be an investor to qualify to bring a claim under the bilateral investment agreement. Another area that's had a lot of jurisprudence is whether direct and indirect investors, even minority shareholders, can bring a claim. So if we focus on corporations, for instance, you will all be very familiar with corporations having very complicated family trees. For tax or other reasons, they'll have interim companies that are in 5 or 6 different countries. So the question has arisen, do you start at the beginning, the parent company? Is that dispositive for purposes of nationality? Are you able to take into account these interim companies? And if so, does that change the nationality of who can bring a claim? And there have also been cases that won't surprise you, especially as companies and vulture funds and hedge funds and all these very intricate international investments between companies or transfers between companies occur. The question has arisen, are minority shareholders able to bring claims as investors? If you just have 2% of whatever the investment is, are you able to actually gain access to something that's hugely valuable, which is an international system where you can actually sue a country? So it's an extraordinarily valuable right. Is a 2% shareholding enough to trigger it? So this gives you a sense that although the treaties themselves tend to be short, most BITs are 5-7 pages, each and every word, I can honestly tell you, has been litigated to the nth degree at this stage because all of these different scenarios have arisen since they were first negotiated. The other one I'll mention is locally incorporated entities. That's a situation where you have a foreign investor, but in order to meet investment requirements in a host state, sometimes you have to incorporate a company that is organized under the laws of the host state. In some instances, there was the argument that that local entity broke the link on nationality sufficiently that it disqualified the foreign investor from bringing a claim. Now, that has not taken the day, frankly, in jurisprudence. As you can imagine, if all that a host country needs to do is impose a requirement that you have to have a local entity, and that breaks the ability of a claimant, a foreign investor, to bring a claim, tribunals have not taken kindly to that argument in general, but it's definitely something that's an issue that has been brought to bear in different cases. So that takes me to, we've talked about what's protected. We've talked about who's protected. Then we come to the standard of how are these claimants protected. And this, of course, has been the subject of lots of different cases that carefully try to parse out what these various protections mean. I'm not going to go into detail in all of them, but there'll be lots that will be familiar. I think even though these are obviously international concepts contained in international treaties, there's usually some analog in a domestic context that gave rise to it. So, for example, on the international plane, expropriation. There's both lawful and unlawful expropriations that are usually defined by the treaty themselves, and it's expropriation without adequate compensation. The domestic analog to that is really takings clauses. So takings legislation in different European, US countries, in Africa, those are the statutes that are the analog to expropriation internationally. So my point is that these are familiar concepts, and what these treaties have done is basically internationalize what domestic systems have long held are limits on state conduct. So countries, governments are not supposed to take property without adequate compensation. There's some situations where it's considered lawful because a state needs to exercise its sovereign powers in certain circumstances, including in times of national emergency, necessity. There's plenty of justifications. But even lawful expropriations need to have fair and adequate compensation in order for a breach not to occur. And that's exactly what occurs in the substantive portions of these treaties when it comes to expropriation. The other one I'll mention is fair and equitable treatment, FET. Who's heard of FET clauses? They get a lot of, I'd say, high-profile moments of FET clauses. I see people nodding. So this has been, I'd say, one of the most controversial aspects of these international system of justice. And the reason for that is that this concept has been the subject to much evolution over the years. So fair and equitable treatment is as it sounds. It is the idea that investors are owed due process. There needs to be fairness. There cannot be arbitrary conduct. There cannot be discriminatory conduct. But what that actually means in terms of underlying facts is obviously the subject of a lot of different, I'd say, debates, controversy, and different decisions across the board. One of the most significant is a concept called legitimate expectations. Now, this drives sovereign states insane, this concept of legitimate expectations. It was a matter of jurisprudence around the fair and equitable treatment standard. The idea that fair and equitable treatment can be manifest where certain representations are made to foreign investors as a means of saying, you should come, invest in my country, here's some protections that we're willing to grant you. They're not manifest in domestic laws as such, but we, the government, will give you, the specific foreign investor, these protections. To the extent that they're written down, there have been cases that have argued that these specific representations made by a specific government official in a specific circumstance, if they are not met, gives rise to a treaty breach, which is pretty extraordinary if you think about, especially you, as you go through and have lots of conversations with lots of outsiders. In some circumstances, the idea that any representations you're making, let's put it in the context of a foreign investor, could potentially give rise to a claim down the line. And that's an extraordinary thing to think about. And that's one of the reasons why that concept is considered quite controversial. And so there are many states that have said, for example, FET is restricted to the minimum standard of treatment under customary law. What that does is it takes legitimate expectations in this kind of, I'd say, FET on steroids, if you will, off the table. Because it says what the state owes is a minimum as under customary law. And it's really, I would say, pretty difficult to demonstrate that the concept of legitimate expectations, et cetera, rises to the level of a customary legal protection. So it's just one example of how these standards evolve. There's jurisprudence. Now, of course, this system is not one that employs res judicata. It is not a system where one bit, a decision, an award under one bit, is supposed to influence the disposition of a claim under another bit, even though the language tends to be exactly the same. Why is that? Because these are disputes in specific situations, and this is not an internationalized jurisprudence where one tribunal thinks of itself as bound by the reasoning of another tribunal under a different treaty. Having said that, if you look at any brief in any of these cases, this authority, tribunal decisions, is considered persuasive. It's argued as persuasive. So it's not binding on these tribunals. But in the last 60 years, as these cases have proliferated, that it's argued, this jurisprudence in and of itself is argued as persuasive. So you have these briefs that cite to myriad decisions on myriad questions that other international arbitration panels have come to. And that's kind of, again, that internationalized system of justice that's very much continues to be in flux. There's jurisprudence under all of these other substantive protections: full protection security, arbitrary discriminatory measures, most favored nation treatment, national treatment, and umbrella clauses. Most of these speak for themselves. I will pause on the umbrella clause as yet another point of controversy. The umbrella clause is usually in the treaty very short. It is the clause that's supposed to capture everything else, right? It's literally one of those inclusive clauses. And over the years, the idea that these so-called umbrella clauses bring in other types of claims, for example, contractual breach claims, does it fall within the treaty? And again, it's an area that's very interesting. Jurisprudence has arisen around at what point does a mere contractual breach of a concession contract or otherwise rise to the level of a treaty breach? The idea being it can't be the case that every contractual breach constitutes a treaty breach, given the ramifications for host countries. So there has to be some kind of materiality to it, if you will. And that also has been the subject of lots of decisions and jurisprudence over the years as to when does the umbrella clause sweep in claims within the ambit of the treaty. So this gives you a sense of the scope, but if you get the impression that it's broad-reaching, it is. These are very broad-reaching protections. And so again, consent from a respondent state perspective needs to be paramount, always keeping in mind what are the limits of the consent for the types of disputes that the country, the host country, agreed to submit to arbitration. So that gives you, I think, a sense of the large parameters around and of what this ISDS system looks like. Are there any questions on that before I go into some of the trend lines? Yeah, please, go ahead.
Sorry, I have a question. On the last slide, I don't know where non-disclosure agreements are likely to fall, and I would like to hear your opinion on the same, where investors enter into an agreement with the state, and there is a non-disclosure agreement, and so the citizens are not in a position to know the particulars of that agreement. There are loans involved, and it is the citizens who are paying for these loans through their taxes. I think in Africa it has been a very big issue, and it is creating an argument of odious debts because when there's a non-disclosure clause in an agreement, then the impression that is created is that there's something that has gone in between, and that the actual costs of the investment is much lower than actually what has been declared, and that there's some loot that has been shared in between. So what is the place of the non-disclosure clause in an agreement in all this?
It's a really good question, and you've hit on something that has been much debated, which is what is the role of confidentiality in these types of proceedings? And as you say, sometimes, for example, they'll be say it's a concession agreement, it'll be subject to confidentiality. So you have the sense that the state has agreed to certain dispute resolution, but it's subject to confidentiality, and that needs to be respected in some form, right? So then the question arises that you've posited, which is, what if claimants basically circumvent the non-disclosure clause, the confidentiality clause, by just raising a treaty breach, which in and of itself, that proceeding isn't by default confidential. These BITs don't typically have confidentiality clauses. So that is a situation where sometimes you can't control, obviously, what claimants do with their request for arbitration. It may be that some claimants try to create, for example, some negotiating leverage by taking their international request for arbitration and leaking it to the press, so it gets all over the press. And then the respondent state is faced with a situation where they thought they had a confidentiality protection, but the treaty breach allows the circumvention of that protection. And that's a situation where respondent states, and I've been in a couple of situations where the respondent states then, when the tribunal is constituted, basically make arguments to the tribunal that this is what was negotiated around this concession, this is what was important to be kept confidential, and this respondent state wants to enforce it in the context of the international arbitration. That can succeed to varying degrees. Usually, arbitral tribunals will not close the entire proceeding if the claimant objects. Sometimes the claimant won't object, and then it's all confidential. But if the claimant objects, they won't usually close off the entire proceeding, but they can put in place a confidentiality order that protects certain information. And then the respondent state designates information that's sensitive, and then the arbitration proceeds on the basis that some information will never be made public. And that happens fairly frequently. It's not perfect because it's already out in the public domain, but it is some ability to enforce those kinds of non-disclosure expectations by states. The other difficulty, though, is that because these disputes arise under treaties, because public funds are at stake, there is a sense of transparency, that there is an important mandate, if you will, that these types of investment arbitrations are transparent because they implicate public order policy issues. And so in the ISDS system, you also have to be aware and sensitive to the idea that these public order type disputes are subject to some kind of transparency because the public is entitled to know the kinds of disputes the state is getting into with investors. So it's particularly difficult to enforce confidentiality in the context of ISDS. Whereas in one of those categories that I showed you on the commercial arbitrations, those are almost default confidential. And so unless there's a leak, those stay confidential. Not the case with ISDS. So when you have sensitive information implicated in a dispute, it's really important to work with your counsel to put protections on it to the greatest extent possible. But I will say it's a really good question because it's quite challenging in ISDS. Any other questions? Yeah, please.
Thank you very much, Professor. So I think, as you said, many protections are common to national systems. So, but when you can rely on both domestic courts and international arbitrations, what kind of factors would you consider to select the tribunal?
Is the question whether domestic decisions are considered persuasive in the international disputes?
Yes.
Okay, no. But that's too broad of a brush. I think there are occasions when, for example, we've cited to domestic decisions, but usually in the context of explaining the interpretation of a term in the treaty. So there has to be a general relevance to it. To give you one example, some of these treaties have exhaustion of local remedies as a prerequisite to bringing in arbitration. So what you have to do under the treaty in order to qualify to bring in arbitration in the first place, it's an admissibility objection if you don't, is you have to go to the domestic courts and take it to the highest level of the court. And you basically have to go, and that can take years, as you know. In that situation, there's lots of domestic court decisions that are relevant to the actual treaty claim that's before the tribunal. So there's certain instances where it does become relevant, but for the most part, if, for example, a host country has a domestic takings statute, and there's jurisprudence around the takings statute, the international tribunal will hear the evidence, but won't find that persuasive for how the international standard of expropriation should be interpreted, because it's considered to be distinct from any one domestic jurisdiction. It's supposed to be an internationalized definition. So that's why there's some limits to how you can cite to domestic cases. But there are instances where they are relevant and they should be cited. Any other questions? Yeah.
Thank you. In the arbitration space, is it an each bear own legal costs jurisdiction, or are there cost consequences for particular outcomes?
Really good question. Those cost consequences are not contained in the treaties. Not surprising, right? That's a level of detail that won't get to the treaty. But where they're administered, for example, under the ICSID rules, there's specific rules in ICSID, UNCITRAL, different institutions, ICC, that go specifically to the question of costs. So the short answer is it depends. If there's an explicit rule that deals with costs, you basically go under the rule and you make a claim for costs. In most international arbitration at this stage, I would say the critical mass of decisions are that the costs follow the event. What that means is that the winning party is entitled not just to whatever damages award that it's obtained, but also to have its reasonable costs, both tribunal costs and attorney reasonable fees, compensated. So I'd say the last 5 years, when I have argued on behalf of respondent states, when we win, we've gotten costs, which has been fabulous. So you can imagine, not only do you win, you get all of your legal fees and tribunal costs awarded, and it's subject to interest. So we've had very happy clients who've had the interest and have also in sometimes encompassed. So it's a really good question, and one of those issues that you should have top of mind when these disputes start. How are you going to approach cost? Because unfortunately, these cases are pretty expensive. They're really expensive. They go year after year. The damages experts alone, I don't want to shock anyone, I've spent $1 million just on the damages expert calculation, because they're extraordinarily complicated DCF or expropriation models that have to be built. So these are really expensive cases. So the question of costs is something that I think should be on everyone's radar very early when a dispute arises. But at this stage, the critical mass of decisions is the costs follow success, and that I think is a positive development. Any other questions? Okay, yeah, please. And if you wouldn't mind just saying your name and where you're from, I'd love to.
Thank you very much for your presentation. It's very interesting. I am Sandra Michel from Seychelles, the Republic of Seychelles. Something that concerns me is the vulnerability. You just mentioned the cost of arbitration cases. We are very much aware of that. We have a case that we lost in Seychelles against a foreign company and it was simply the case that the company had a number of lawyers. They were well prepared for the case, and we were not. We did not have the human capacity to represent the country in the case. We lost the case, and because at that point in time, we had already acceded to the 1958 Convention on the enforcement of foreign arbitral awards. We had to execute the decision of the arbitration, and the company was lost. It was an important company for us. But my point is, you mentioned that in the 90s, there has been an exponential increase of cases. Do you think that this increase is due to the fact that developing countries have found ways to go to arbitration by securing more successful outcomes?
That's a really good question. And I want to come back to this as well. There is a very fair criticism of the ISDS system in the sense that developing countries, especially small island states, you name it, is disadvantaged because of the resource differential between a foreign investor and the country. So there's actually been some, I think, good talk about establishing a global fund where basically there's a sense of that expertise should not be accessible only to those that can pay exorbitant fees. So there's been an international conversation around that I'll come back to. But to your question, I think the sense is that, and this is a perfect entry into what I'm going to talk about next, but the sense by developing states and why so many developing states started to conclude BITs, including BITs that could potentially make them subject to these international claims, is the idea that by signing a bilateral investment treaty, you are going to get what's called foreign direct investment, FDI, more FDI, which would obviously benefit the host state to a great degree by contributing to the economy, creating jobs, opportunities. So that's the basic premise of why so many developing states signed up to BITs in the 90s. It's why the system has endured for almost 60 years. It's because of the idea that there's a benefit on both sides. The foreign investors get a benefit in thinking of there could be accountability if there's arbitrary state conduct, and the state gets the benefit of the foreign direct investment, the FDI. I think that's what was driving what happened in the 90s. But to that point, I want to talk about FDI. As I mentioned, the basic premise is that BITs lead to increased FDI. A respondent state that signs on the dotted line and agrees to protect investments and be subject to arbitration if they don't is important enough to foreign investors that FDI goes up in that host country. There have been, because we are now 60 years into the premise, there have been myriad studies by social scientists, by political scientists, trying to actually establish, is there a causal link between FDI going up and the signing of BITs by a host country? So who thinks that there's a causal link? Raise your hand. You guys are good. Who thinks there's a correlation, which is a level below a causal link, which means that the BIT doesn't cause FDI to go up, but the more BITs a host country signs is correlated to an increase in FDI? Who thinks there's a correlation? Maybe. Yes, there's a correlation, but it's not a strong one. It's really interesting because the entire premise is that you'd actually get the benefit of increased FDI if you sign on to these treaties. There is an established correlation, but from a quantitative perspective, it's really hard to gauge that with any accuracy, with any empirical accuracy. I was once asked to do a peer review on an article that tried to do that, to try to establish that connection. But when you go into their model, the underlying model, the statistical analysis probably wouldn't pass muster under any real scientific rigor. It's, in some sense, this is the classic question that remains somewhat unanswered. But I would say the general sense is that there is a correlation between the signing of these BITs and FDIs. And of course, FDI is really important to a lot of countries. And why? I mean, look at the kinds of numbers that we're talking about. So 2024 FDI net inflows were 605 billion in Asia, 97 billion in Africa, and this represented significant increases of inflows from the prior year. Several economies in Asia were also among the top 20 home economies of FDI outflows: Japan, China, Singapore, Korea. So it is big business, FDI. It is a lot of money flowing through an internationalized system, and that's why you still see, even with some criticism of the system, a lot of these treaties continue to be enforced and these mechanisms continue. So I wanted to give you one example of what it means to think about FDI trends when it comes to anticipating disputes. So one place that I think we're going to see, we have seen and will continue to see, a lot of potential for disputes under these treaties is in energy transition. And the example up on the slide is energy transition in Asia. I've given you some sites of, for example, Southeast Asia and renewable energy sector, upward trend, expected to grow rapidly. And the Asian countries as biggest investors in renewables in the region, Japan being a very good example of that when it comes to geothermal and solar. And these investments are on the order of billions and certainly several hundreds of millions. And China was one of the biggest investors in wind, for example, at 1.28 billion, and hydropower at 1.1 billion. So these kinds of transition commitments involve a lot of FDI, which is not surprising to anyone. And they fuel a lot of different, I'd say, impacts on demand in both upstream and downstream renewable energy activities. So why does this throw out disputes? Because lots of host countries are looking at energy transition. And I know that Niloufar spoke to you about the climate change, for example, in international law, and the recent ICJ decision, which clarifies state obligations in the context of climate change. So there's going to be state action, one way or another, around energy transition. Now, when states create, for example, renewable energy subsidies, foreign investors who take up those subsidies then become foreign investors in that state, then have rights under these treaties. And say, for example, in year 3, the subsidies are pulled because the country has to go in a different direction. Does that foreign investor have a claim? So renewables are just a classic area where you see a lot of state activity, a lot of policy, economic policy making in the form of subsidies, tariffs, you name it. And when that changes, it throws off disputes. So, and here I have some investment figures in Africa, but again, renewables all over the world is a very important and targeted growth area and has been for at least the last 5 to 7 years, if not longer. How do we know these throw off disputes? Who's heard of the Spain, all of the cases against Spain for its renewables under the Energy Charter Treaty, ECT? Okay, I see some of you. This was a big, I'd say, moment in the sense that you see a country that undertakes a certain renewables policy. That policy becomes extraordinarily costly for that country because of it had to do with subsidies and tariffs and different levels of tariffs and what foreign investors could opt into for a certain number of years to give them certainty. So it was a means by which Spain very much was successful in drawing foreign investment. But it became a financial disaster, and Spain changed its policy. There were over 50 treaty cases filed against Spain under the Energy Charter Treaty around this one regime change. So you can imagine what that caused in terms of Spain as a respondent on the international plane, responding to these various claims. And tribunals looking at this scheme have come to mostly consistent with some outlier conclusions. I've just excerpted one of them, which is the Nova Energia v. Spain in 2018, where it gives you a sense of what the tribunals were considering. So what they said about the measures enacted by Spain when it changed its subsidy program is that they didn't fall outside the acceptable range of legislative and regulatory behavior. Of course, a state is entitled to change its economic policy and sector-specific economic policy. But the tribunal found that the claimant had a legitimate and reasonable expectation that there would not be any radical or fundamental changes to the subsidy when it made the decision to invest. And therefore, there was a violation of the FET standard, the fair and equitable treatment, because they were radical and unexpected. So that gives you a sense of how these tribunals are struggling, really, to take the power to regulate, which is obviously something the state has authority to do, to regulate for the benefit of its population, and balance that with the idea that if an investor is told that it's going to have certainty because of X, that if X changes to Y, that there's a legitimate claim that can arise and a treaty breach. This is also part of the reason that I mentioned that the legitimate and reasonable expectation aspect of the FET is pretty controversial, because there you really do have a granular, I was told X as an investor, you did Y, and it rises to a treaty breach in a way that impinges on the power to regulate. Now, of course, none of these cases actually stop Spain from enacting whatever economic and renewals policy it wants. These are not injunctive cases. These are cases about damages. So Spain has its power to regulate. The question involved in before these tribunals is there compensation owed because there's a treaty breach of the fair and equitable standard? So that's how it manifests. But I thought it was a good example, especially given all of the conversations that we're going to have as a globe, on a global basis, around NDCs, climate change, renewables policy, energy transition. You can expect that these types of policy decisions are going to intersect with the investment treaty system in some pretty interesting ways in the coming years. So it's something that I wanted to put on everyone's radar in that sense. So the next section I wanted to talk about this is where I wanted to get quite practical in terms of if you come across these types of disputes in your portfolio, what do you want to think about and think through in terms of strategic considerations? So there's top 5, none of which is going to surprise you in terms of what I'm going to say. But I'll start with institutional coordination is key. Now, of course, that's easy to say. Within the context of most governments, it's extraordinarily difficult to accomplish. And I know when I spent time in the US State Department, the coordination that I had to do to, for example, give a 30-minute speech before a UN body was extraordinary. It took, I think, 5 months of negotiations in the interagency in order to get to kind of a single statement that was fairly uncontroversial to begin with. So you can imagine that when it comes to these kinds of complicated policies, the coordination is key, but it is very difficult for governments to coordinate in this fashion. There's 2 aspects of coordination, though, because it's worth doing this because it will save a lot of pain down the line. There's 2 aspects. One is, before a dispute ever arises, is trying to create a holistic and cohesive international investment policy. Coordination between the different ministries involved. Think about the license application review, the tender document interpretation, calls for foreign investment. How is the government portraying to foreign investors what the investment climate is? What are the representations being made? It's important to kind of make sure that coordination occurs across all ministries who have a role to play. And it's important that coordination take account that there's lots of different stakeholders that you're speaking to as a government. So it's obviously, while the voice should be unified, it also needs to be nuanced. So you have the investors, you have the general public, civil society, NGOs, This is all quite important to take account of in shaping the economic policies that may ultimately give rise to these kinds of disputes. And there have been cases actually where the claim itself was based on something that the foreign ministry said that was in direct contradiction to something the energy ministry said. Again, happens all the time, but imagine in the context of a dispute how much impact that can have on whether or not a claimant succeeds. So part of this is get ahead of those disputes, think about through the various ministries how to bring together a cohesive policy that takes into account all of these stakeholders. Then there's the moment of a dispute arising. Never a happy moment, but one where internal coordination really does need to become paramount. So most investment arbitrations at this stage, even though largely handled, in my experience, by MOFA or MOJ, depending on the government, actually touches a lot of different ministries, whether it's aeronautics, energy, it just depends on the subject matter of the dispute. And so the fact that various ministries are touched means there needs to be some type of coordination, including where there's 5, 6, or 7 different departments or ministries. One particularly difficult challenge is that coordination can't take months upon months, because often when a dispute has arisen, you're under the clock. There's a timetable for when the answer goes in. There's a timetable of the submission of the defense. You have to nominate arbitrators. There's so much that becomes time sensitive. And if this coordination is not in place in certain governments, it can mean something as fundamental as waiver of rights. I have seen respondent states miss the ability to appoint an arbitrator, which, as I'll get into in a minute, is one of the most important decisions in an investment dispute. So this idea of coordination, very difficult, I don't underestimate the difficult and the practicalities of it, is frankly necessary. I have had some respondent state clients to very good effect actually form, when a dispute arises, a committee that has representatives from the different ministries that have an equity in the claim, and that committee has the ability to make decisions quickly enough so that there's no waiver of rights. And so that's one construct that you might consider, to have specific dispute committees that are interagency, that have the ability to deal with most of the routine decisions working in conjunction with the lawyers, while at the same time have the judgment that if there's anything that is really strategically important that needs to go to a higher level for approval, that communication channel is there. So I've recommended that to clients to very good effect, and I think it honestly made the difference between a successful claim and an unsuccessful claim defense. So again, can't emphasize this enough in terms of coordination. The second point, again, very obvious, engage early and actively. The reason for that is that the initial days of a dispute, the initial weeks, the initial months of a dispute, are probably the most important and determinative of the ultimate success of the respondent state with respect to the claim. The reason I say that is if the strategy, the basic strategy, the preliminary claim assessment, understanding of defenses, the document approach, the fact witnesses, the expert witnesses, if the elements of that strategy haven't been determined in the first 3 to 4 months, then you're going to significantly weaken the ability to successfully defend the claim. And the reason I say that is that much of what the strategic decisions that are coming down the pike, because these take years, right? And I'm saying you need to have it all figured out in the first 3 to 4 months. I don't say that lightly. You don't need to have it all figured out. But the basic planks of the strategy need to be clear and apparent, because there's so many implications and decisions that flow from every ministry's understanding that these are the basic planks of the defense. And so that, I think, is really critically important, which is why early and actively engage with your lawyers, get a preliminary claim assessment, understand how you're going to assess relevant evidence and preservation, which I'll come back to, Whether you're going to use external counsel or you're going with the in-house team is an early decision. Whether and how to manage deadlines to preserve rights. I mentioned early on there's lots of very significant deadlines. Drafting correspondence with the future strategy in mind. Sometimes there will be the notice of dispute that gets sent because there needs to be a negotiating period. The state's first response when there's no coordination can be one of the most deadly pieces of evidence in the claim as it progresses. So once a dispute arises, every piece of communication needs to be viewed as potential evidence and come and be drawn from and derived from a defense strategy that is consistent throughout. So that's why I say the early engagement is really important. And then the vetting of arbitrator candidates I'm going to come back to because it's so important. So what are the kinds of strategy points that arise early? This is it's not a comprehensive list, it's an indicative list. So on the procedural requirements, many bits have cooling off periods, negotiation periods, usually around 6 months. So there's an attempt to negotiate the dispute that needs to occur before the claimant actually can lodge an arbitration. It's amazing how little negotiations is employed in investor-state arbitration, even though it's baked into the treaty. The claimants typically send a notice of arbitration. Months go by with no answer, and there's really no substantive conversation. That is the majority, I would say, of investment arbitration disputes. And part of it is because 6 months is not a long time for a state to actually coordinate sufficiently internally to engage in negotiations. That's one. Two, it's structurally, and some claimants don't appreciate it, very difficult for a state to come to a decision of the terms of negotiation that could actually resolve a dispute. Three, not many officials want to be the individual signing a settlement agreement with a foreign investor because of all of the knock-on effects internally and externally. So there are some very, I'd say, structural impediments to negotiations that aren't fully appreciated by lots of claimants, but certainly in my practice in representing respondent states, it's very apparent. So, but from a procedural perspective, there still needs to be at least 6 months cooling off period before a claimant can initiate. There's a fork in the road provision. One thing that respondent states need to be attuned to is if it's one of the treaties that requires a claimant to choose, fork in the road. You either choose a domestic remedy or you choose a treaty remedy. You can't do both. So that's actually disqualifying. Sometimes claimants don't realize that. They start a domestic proceeding, and then the question becomes, well, this is inadmissible because the fork in the road clause in the treaty means you've chosen and you no longer have recourse to international claim under the treaty. So that's something that very early needs to be assessed. Exhaustion of local remedies, I've mentioned that. It's an admissibility requirement. It's the opposite, I suppose, of the fork in the road, is have you taken it to the highest court? There's a concept of futility that's developed over the years where lots of claimants say, I don't have to fulfill that requirement because it would be futile because I know I'm going to lose in the domestic courts against the state. So that's a concept that's arisen, but it's something that needs to be considered early on. More and more, I find that there's multiple proceedings around a single dispute because sometimes claimants will just go all in and initiate claims in any potential fora and possible fora. So there'll be a treaty dispute. There'll also be a concession agreement dispute that's initiated. So you have 2 arbitrations that are around the same dispute, and there needs to be coordination. I've had cases in which I've had 2 treaty claims under 2 different bits because the nationality of the claimants were different. So they proceeded under different bits, even though they were the same ownership chain. And I've actually run cases where we have appointed the same tribunal in both of those arbitrations so that the risk of inconsistency is diminished. Because really, there's nothing worse in the sense of thinking about justice and equity to have on the same facts with the same dispute inconsistent tribunal decisions. So there's some mechanisms to think through what it means to have parallel proceedings. There's alternative methods of resolution. These are very difficult for reasons I mentioned, but at every point, there should be a discussion with counsel as to, is there a way to just pull the plug on the dispute? No party, no state wants to be in a dispute year in, year out. It drains resources. It's very, especially in these billion-dollar cases, it causes a lot of turmoil, and it has economic implications because these are public funds that are at issue. So at every point, you should be talking actively with your counsel. Is there an opportunity to settle? Is there a conciliation or other mechanism that can work? And then the other factors is just obviously, from your perspective, take account the political climate. How is the transparency questions being answered? The PR, the media aspects. Is there an opportunity to seek provisional measures? What is the damages risk assessment? It might seem crazy to think through damages in the early days of a dispute, but there's actually a really good strategic reason to think about damages early on. And to give you an example, I had a dispute where it was pretty clear that the facts around the breach were very complicated. It arose in an insurance sector dispute. Very complicated. It was going to take years to find these facts, witnesses, et cetera. Whereas it was very clear that there were no damages. That even if there was a breach of the treaty, the damages were non-existent. So what we did procedurally is we flipped it. We convinced the tribunal to do the damages phase first before we even addressed liability. We put liability on reserve and just did damages. Guess what? 0 damages, case went away. And it lasted 1 year instead of 7. And it's that kind of assessment which makes it so important to engage with counsel so you can figure out what is the best strategy in order to resolve this dispute as successfully as possible. Yes. Oh, I'm sorry. Please. Hey. Hi, Vern.
Hi, Catherine. A question for you on Thank you. Question for you on the sort of settlement possibilities or negotiation or conciliation. One of the concerns that state clients have, in my experience, has been the things you said. We are coordinating among different ministries or agencies. And they have a concern that by looking to settle, they may appear weak, both to the opposing party or to the country at large. They're also concerned that things that they may say in settlement discussions could be used against them in an arbitration. Are there things like formal settlement privileges or tips or mechanisms you use to minimize those concerns and potentially allow for early settlement?
It's a really good question. Is it going to shock you when I say yes? Probably not. I have found that probably one of the most important factors in a successful settlement is confidentiality, is to create a safe space for the parties to be able to be quite frank with each other, as frank as possible, about what would be acceptable to resolve the claim. So I found that actually formal mediation, because sometimes you go into a negotiating context, and even though both sides have agreed that something's going to be confidential, there's still risk. There's still some sense that something could get leaked, because at that point, you're obviously at the point of lowest trust between these two disputing parties. So I found that formal mediation structures actually are helpful. But again, it is pretty rare for a state client to want to mediate, at least early on. I've had more success where and one thing we do in our practice is we keep settlement on the table at all points. So for example, if we get a positive provisional measures decision, that is a strategically robust point to go to the claimant and say, do you really want to do this? Let's talk. So I've had some successful settlement discussions, but not in the initial phase, rarely in the cooling off period. There's just too much information deficit, coordination that needs to occur on the state side. But from my perspective, lawyers should be attuned to every potential possibility where there's a moment of leverage, where there's a successful jurisdictional decision, for example, on, say 80% of their claims get dismissed. Can you actually negotiate around the remaining 20% so that you're not spending the next 4 years on a merits and damages hearing, but you get rid of the case? So I think it's still not as frequent as I see on the commercial arbitration side, but I find that formal mediation can sometimes create that confidentiality in a way that's useful. But have you used formal mediation in the context of investor state?
No, my experience has been to never have had formal mediation at the negotiation cooling off period at all.
Yeah.
Sometimes happen later on, and especially But then, thank you. Then there may be a discussion about settlement in terms that are different from the award itself. And you're right, it's a stark contrast to commercial arbitration, even involving state-owned companies where there may be formal mediation and settlement upfront. Sometimes I think that has to do with ongoing contractual business relationships between those state companies and private companies, which results in earlier settlement of disputes.
That's right. And that's actually another factor is in some instances, these claims arise because the company has decided it will no longer do business in the host state. And in those situations, settlement is very difficult because their value of their business is basically now a claim. But there's other instances where the company would prefer to continue operating in a host state, and there, as you can imagine, there's more room for negotiations. So the next one I'll mention, and I won't be long on this, but if the idea of a document discovery process fills your heart with fear, it should. It gets really tricky in the state context, and it's something that it's really important to think through early on what that looks like. There have been some unfortunate circumstances where the state, for example, doesn't have a robust enough document discovery process in terms of preserving documents, making sure that relevant documents and material are gathered, that there have been adverse inferences found against states just on the basis of a deficient documentary discovery process. So where we are is typically investor-state arbitrations involve document production. Luckily, it's usually not at the same level as domestic, which, as you can imagine, can get really robust. The IBA standards are helpful in that they set a basic threshold of relevant and material. And so there's been lots of argument in front of tribunals, and when I sit as arbitrator, one of the main things that I do early in a case is decide discovery disputes because they're really important. And for me, it's about that level of materiality. It has to be material. It's not sufficient that it's just relevant. And that's contained in the IBA rules. So this is just, again, something to put on the radar. In some instances, depending on the circumstances, we've actually issued, even within a government, a written document preservation, which goes to all relevant ministries, because you want to show the tribunal that reasonable steps have been taken to preserve the documents that could be relevant and material to the case. So again, it's just something that, if you can imagine, if you don't do it early, it loses its efficacy. So it's a conversation to have with your counsel early on in the life of a dispute. But it is not pretty. Document discovery is not pretty. The other one I wanted to highlight is arbitrator selection. This is where cases are won or lost, and this is where I think the value add of counsel is perhaps most paramount. This is one of, if not the most important decision that will be made in the life of the case. And up here on the slide are some criteria for consideration. It is one that requires, and I'll show you in a moment, lots of due diligence, but some of the factors is experienced arbitration, independence, impartiality, of course, nationality, language skills. Availability is one that people don't do often enough. There's a lot of repeat appointments. I know when I'm appointed as arbitrator, I make sure, especially if I'm president, that I have time to do the case. There's nothing worse than litigating a case and then the tribunal sits on the award for 3 years. It really has to be about availability, and that's important to ask the arbitrator up front. Capacity to travel. We live in a world where arbitrator pool skews a bit old, so you have to ask the question, is the individual able to kind of work full-time? Capacity to travel is actually one of the points that's important to suss out. Knowledge of the applicable law. It doesn't have to be from the applicable law, but there could be, international law obviously has its own competence and expertise. Sometimes the domestic law may be material enough that you want your appointee to also understand the context in which the investment was made. So that can become relevant. The industry or subject matter expertise, a lot of times whether or not something is fair is industry specific. And so especially in pharma, lots of technical information about how regulatory environments operate would be really useful in an arbitrator candidate. And then this last one is collaboration and synergy. You want to think about your appointee, and how your appointee would interact with the president of the tribunal. That's actually a really important point, and it's one that I think doesn't get fully considered by states in particular, and that's one that's really, really important. One caution I will give: the role of the party-appointed arbitrator is not to be that party's advocate. They lose credibility with presidents if they come in with a bias. And it's basically, in my view, a waste of an appointment, because then you have someone who's not going to do the job, which is not to be a biased advocate. It's to make sure that your case, the respondent state's case, is fully heard, that there's opportunities for the respondent and their counsel to address any gaps in the case, evidentiary points, make sure that all of the questions that are on the minds of the tribunal are given light and air so that the advocates can do the best job possible in addressing those concerns. So the best appointees are those that meet independence, impartiality, have a reputation for rigor, experience, commitment, the time to do the right job, who don't consider them as advocates. Because I really, and there may be those that disagree with me, I feel those are wasted appointments if you appoint someone who's there just to voice one side, because no president really is going to consider them, in my view, in a favorable light. Any questions on arbitrator appointments in that sense? Okay. I've put up here the due diligence. It is very extensive. What we do at Debevoise in terms of due diligence is extensive. It's not just a matter of the CV. All previous decisions and awards issued, viewed in light of the particular dispute. So if we know that FET is going to be a major part of the dispute, we will read every FET decision, every expropriation decision of a candidate before appointment. Includes publications, speeches, presentations, industry-specific arbitrator rosters, and the one big one that you can't replicate is reputation. It is a fairly small world. I think I tend to know most, 25 years in, most of the arbitrators in the pools, in the international arbitrator pools. We know each other, we work with each other. I have a sense of temperaments, approach. Is someone very much contractual, very much about contractual terms or treaty terms. Others favor equity more. It's all a mix, but that's one place that your counsel is very well positioned to give you advice as to what's the right profile given a particular dispute. The other note of caution, and I put it in red, is pre-appointment interviews. You have the opportunity to talk to your arbitrator prior to appointment, but those are limited to availability and conflicts. Sometimes some respondent states think it's an opportunity to interview them about what's your approach to FET, how do you feel about nationals of a certain country, whatever it might be. That is not appropriate. That's considered an ex parte communication. So these appointment conversations are really about availability and conflicts. And that's just something that I've seen go wrong in enough situations that I wanted to make sure to put it on your radar. All right, so next is the develop best arguments and evidence. So I think here, again, very obvious point. The point I'll mention is on potential defenses is to think about this as early as possible. There's defenses on jurisdiction admissibility. There's non-qualifying investments because they don't meet the definition of investment. There's illegality, which is that the investment itself was not legal under the domestic laws of the host country. That is disqualifying. And various admissibility requirements, whether it's fork in the road, timing, whatever it may be. So there's an opportunity to think through what jurisdiction admissibility looks like. The other trend line I'll mention is corruption allegations. I'm actually seeing in the last, I'd say, 7 years or so, a significant uptick in corruption allegations being made, usually by claimants in the context of trying to prove a treaty breach, so unfair arbitrary treatment because of corruption allegations. that's coming more and more into the investment dispute system in a way that wasn't true 10 years ago. So it's just something to sensitize to. Those are very specific, fact-driven, highly politically sensitive investigations. And so coordination with counsel, if corruption allegations are made in the context of requests for arbitration, becomes really, really important early on. And those are probably the most sensitive conversations I've had in the context of advising respondent states. And then on the merits, there's treaty exceptions. In some of these, I'd say, modern generation bits, there's actual exclusions where the state preserves for itself the power to regulate in very specific ways. They're called exclusions, exceptions clauses, which won't surprise you to learn national security, for example. That the power to relegate is so important in the context of national security that baked into the treaty is that you can't have claims that implicate the national security power to regulate. The same with some environmental, we'll say environmental claims, sustainable development, human rights. I think you see these more in the modern generation bits. I think, for example, the environmental exclusion is going to become even more important in light of what we've talked about already about some of the climate change policy actions that are to come. So it's going to be a very robust question when it comes to defenses for respondent states. Does it fall within an exclusion? And those get litigated with, I wouldn't say frequently, but certainly have had cases that either rose or fell depending on the scope of the exclusion clause. One interesting thing about it is that if you're familiar with the national essential interest in the WTO context, the idea that it's self-judging, that a state, once it invokes a national security or essential interest, it's over. The claim's done. It's done because it's self-judging. Once the state invokes, there's no scrutiny that applies. That's not really the way that investment arbitration tribunals have taken. They have said that they continue to maintain a role, that these clauses are not self-judging, but that's been an interesting line of jurisprudence around how these exclusion clauses work. The others are police powers, the authority to regulate and police powers. How does that balance with what the claimant says is a treaty breach? And then the CIL, of course, necessity, force majeure, duress. Argentina has very famously raised necessity as a defense in many of the investment arbitration claims against it for its debt. And so it comes up a fair amount of time. What is the defense available under CIL? And then finally on damages in quantum, as you've heard me say, never too early to think about damages in quantum, lack of causation, speculative nature of the valuation, all things that can drive the strategy from the very beginning of the case, so really important to look at. On the developing the evidence, I'll say it's really a matter of trying to minimize disruption to the work, the really important work of government officials, while still launching successful defense. It's a balance. And so sometimes I find counsel are completely overzealous. They'll tell a government 70 people's documents need to be preserved and frozen. And it just causes such massive disruption. I think here a lot of rigor and discipline and frankly experience as to what is realistic that an experienced tribunal will do in this context. I certainly, when I sit as arbitrator, consider the burden of document discovery and evidentiary development, especially for sovereigns. So it's something that just needs to be a conversation with counsel, and in my view, needs to balance the disruption to what government officials' important work they're doing day in and day out. The other is the need for fact or expert witnesses. There's no government official that has ever volunteered to be put in the witness chair and subject to cross-examination. It is extraordinarily difficult circumstance. It's really a no-win situation for government officials. So we take that consideration very much into account in terms of developing the strategy. And one way to take it into account is to look at the documentary record, because in some instances, you actually may not need a government official testimony. And it just should be part of the consideration just because of the burden that this places on governments. So another point to think about when developing the evidence. The next is the idea of a respondent state as respondent only. Here, it may surprise you that there is an opportunity for respondent states to lodge counterclaims. I'd say this is a relatively recent development in the last decade or so. Tribunals have been inconsistent on this point, because if you read the treaty, it tends to be a one-way ratchet, if you read it on its face, that it's about claimant investors lodging claims against respondent states. It's a rare bit that actually speaks in any specific terms about counterclaims. What can a respondent state do? Having said that, there have been tribunals, I would say probably a minority of tribunals at this stage, who have found that the general bit language that subjects all disputes, that's typical bit language, all disputes are subject to the dispute resolution clause, that actually can give rise to counterclaims by respondent states. And you see the rationale of the tribunal here, where they say all disputes is wide enough to include disputes giving rise to counterclaims. The need for a dispute, if it is fall within the tribunal's jurisdiction, to be between one contracting partner and an investor of the other contracting party, carries with it no implication that Article 8 applies only to disputes in which it is an investor which initiates claims. That was the reasoning. And on that basis, that kind of reasoning, even on the current generation bits that are not specific as to the ability to bring counterclaims, there have been counterclaims lodged. So I'll give you one of the most famous examples, which is the Urbaser v. Argentina, where Argentina lodged an environmental counterclaim against the claimant. And it was basically asking for damages on the basis of environmental harm allegedly caused by the claimant. And at the end of the day, you can imagine there would be a netting, if you will, of the damages. So the counterclaim has its own teeth. And there the respondent is sitting in the shoes of the claimant. And there it was interesting. It involved a concession for water and sewage services, and Argentina brought a counterclaim alleging that the administration of the concession breached international human rights obligations, the human right to water. And that's one instance in which you see international human rights law intersecting with investment arbitration standards. And in referring to the Universal Declaration, the International Covenant on Economic, Social, and Cultural Rights, the tribunal concluded that in principle, private investors have an obligation not to engage in conduct that destroys the individual's human rights entitlement to dignity and adequate housing and living conditions. So there's a basis even within the investor protection system, and in the second part of the lecture, I'll talk about a case that raised some of these kinds of public order rights, that there is the ability of sovereign states to raise these kinds of claims in the ISDS system, which is quite significant. Ultimately, the tribunal denied the counterclaim on the merits, but importantly for these purposes, the ability to lodge a counterclaim, which is, while not entirely clean, because there's cases that go both ways, that should be considered. Is it appropriate? And it can't be a situation where because the claimant lodged, the respondent lodges a counterclaim, almost like a mirroring effect, because you actually would lose credibility if it wasn't a serious claim. But where there are serious claims, the ability to lodge a counterclaim, I think, is a significant conversation to have with counsel. And then finally, for this section, I'll talk about the post-award options, which is an enforcement regime that is fairly complicated, but one that should be understood, maybe not in the first 3 or 4 months, but part of the conversation in formulating the strategy. But now the award is issued, so where are we now? Now what? There's legal proceedings under various regimes that I'll go into in a moment, where there's some post-award recourse, and it can be set aside, annulment, interpretation of the award. There's post-award, something has gone wrong, we need to address what the tribunal did. So there's some, albeit limited, bases on which to get recourse after an award is issued. Then there's formal recognition and enforcement, which is affirmatively taking a positive award and giving it recognition and enforcement in various domestic courts where assets are located, whatever it may be, that this is now a formally enforced and binding recognized award. And then execution, and here it's a matter of understanding where a claimant may try to execute against assets, and as we'll go to in a minute, there's immunity and other issues that arise when claimants try to execute investor arbitration awards against states. And then even after an award is issued, that's yet another moment for engaging in discussions, potentially taking into account post-award recourse and coming to a negotiated resolution. So yet again, one of those opportunities to potentially streamline, and instead of continuing to fight in post-award proceedings, to actually bring the dispute to an end. Key issues to consider is the priority. What are the policy, commercial objectives of the state? The nature of the claimant. Is this a claimant that wants to keep doing business in the host country, in which case there's some additional leverage? Jurisdiction and applicable law largely depends, in some instances, on the seat, and we'll get into what that means. Impact on post-award options, and location and nature of assets. So where are assets, could they be particularly vulnerable? If I had to divide the world into two kind of categories when it comes to arbitral awards, it would be the New York Convention and ICSID Convention. New York Convention applies to UNCITRAL ad hoc if you're proceeding under those types of rules. They're enforceable under the New York Convention, which is extraordinarily broad in terms of its scope and applicability. And then separately, under the ICSID Convention, which many bits give you the option. You either can do an UNCITRAL arbitration or ICSID arbitration. There's strategic questions that arise as to why you might choose ICSID over UNCITRAL arbitration that you'd need to make sure to talk through with counsel. But ICSID has one particular benefit in that it's an entirely self-contained regime. There's really no domestic court involvement in an ICSID arbitration. So you get the award. If there's some recourse or rectification, annulment goes to an annulment committee that's within the ICSID system. And the award is automatically recognized under the ICSID Convention as if it were issued by the highest court of that host state's territory, in the host state's territory. So it is a very self-contained, supposedly automatically enforceable, streamlined system, but there is an opportunity to seek annulment on a limited basis. And then under the New York Convention, there's more domestic court intervention possibilities based on what's called the legal seat of the award, which can be decided by parties and is designated usually in the governing procedural order. And there it gives rise to certain set-aside and potential annulment basis. But here, set-aside under limited circumstance. You can imagine what they are is if there's bias or corruption in the panel, public policy reasons the award should not be enforced, but very, very intended to be limited exceptions. Revision, interpretation, correction, I won't go into detail. There's different provisions depending on which system this arises under. This gives you a sense of why these arbitral awards are so valuable. These are countries that are party to the New York Convention. I mean, what it does is it takes this arbitral award and makes it enforceable. So this is the non-ICSID version of the arbitral award. Makes it enforceable in all countries that are party to the New York Convention. And at this stage, it's most countries that are party to the New York Convention. So it's quite powerful in that sense, which is why this system has basically been, the longevity of the system includes because of the global reach of what the enforcement mechanisms look like. Immunity is one where if you're thinking through enforcement objectives, it's important to understand that if a claimant seeks to enforce against state assets, most jurisdictions will confer immunity on a state and its property under a rule of customary law that's been adopted by many states in their domestic laws. I've put two examples on the slides under the FSIA in the US and the UK State Immunity Act. But many jurisdictions do distinguish between states and assets that are used for public purpose or sovereign use versus commercial use. Sovereign use being, as you can imagine, state-owned premises leased to provide visa, passport services, bank accounts, public bank accounts used to cover day-to-day expenses of an embassy. Believe it or not, people have tried to attach embassy bank accounts. And so there's jurisprudence out there about how these are public purpose assets that are immune from attachment. So it's important to understand that. It's also important to understand that there's commercial use exceptions. So if a sovereign state is engaged in commercial activities, that can be subject to, in many jurisdictions, seizure. So property leased to earn rent, bank accounts used to settle liabilities, debts owed to a state by third parties in relation to commercial transactions. So this is pretty nuanced, fact-based, but important to appreciate what assets of a state can be subject to execution and what would actually be immune. And one very famous case that you may have heard of was the case of the tall ship, the Argentine tall ship, the Libertad, which was sailing. Has anyone heard of the seizure of the Libertad? Anyone? No? Okay. I mean, it really did make a lot of, for international law nerds, it did make the circles because it was a pretty fascinating example. But the Libertad is obviously owned by the Argentine Navy. It was sailing across the Atlantic, and unbeknownst to them, it was being tracked by a hedge fund that was owed about $1 billion, that owed $1 billion of Argentina's debt, which it was not paying. When the tall ship was supposed to go to Nigeria, it stopped off in Ghanaian waters, in domestic Ghanaian waters, and it was seized. It was seized and immediately went into Ghanaian courts saying that Libertad had to be seized. The ship's crew was evacuated with the captain and skeleton crew on board. This became a major international incident. Was it possible to seize an Argentine naval vessel in furtherance and execution on an outstanding arbitral award? And so, as you can imagine, international controversy ensued. The chief of the Argentine Navy resigned because of the scandal. It just turned into a big international incident. Ultimately, it went before the International Tribunal for the Law of the Sea, which ruled that, in fact, Ghana had to release the vessel, and it actually sailed back to Argentina. It's a high-profile example of how these enforcement actions can really end up in some crazy circumstances. What does sovereign use mean versus commercial use? And ultimately, it took the intervention of the International Tribunal for the Law of the Sea in order to get that released. But I thought that was a very interesting example of how immunity can play in on these types of fulfillment of arbitral awards. So I think we're at the break point. So why don't we pause here? Everyone get coffee that you so well deserve. And then we're back in 20 minutes.
It's wonderful. We'll be starting around 11. Thank you.